Hi, everybody. It's Simple Politics. I'm Kim Wehle. My guest today is Joanna Grossman, who is a professor of law at SMU Law School and an expert in women in the law, author of several books around equality in the workplace and other matters. And she's here today to talk to us about what's happening in the United States Supreme Court around the very divisive, important issue of abortion. Welcome, Joanna. Thank you for coming to Simple Politics.
Thanks for having me.
So let's start, as we were talking before we went on air about, law students and others that watch this program. A lot of things get floated around. For example, I hear oftentimes when I do commentary around this, oh, Roe versus Wade is it's atop a pile of sand. Its constitutional grounding is so weak and so fragile that it's about to tip over. It makes sense that it tips over. Could you talk about what is the constitutional right to abortion, and do you agree with those who just sort of blithely say, "Oh, it's a very weak foundation constitutionally"?
Sure. If you want to think about the right of abortion constitutionally, you actually have to go back quite a few decades to the beginning of the idea of a substantive due process and the right of privacy around family and reproduction, which actually has a much older provenance than Roe v. Wade. So the Supreme Court first recognized that there was a fundamental right of parents to the care, custody, and control of their children in the 1920s. And there were two cases in the 1920s and a third case in the 1940s, in which the Supreme Court, long before any of the cases that people talk about now as being the privacy cases, the court said very strongly, right, that there's this sphere in the family where the government is just not supposed to interfere. And parents have a lot of power, right, to decide how they want to raise their children. So the actual foundation of Roe versus Wade starts there, right? And then you add to that a case, Skinner versus Oklahoma, in which the court said there is a fundamental due process right not to be involuntarily sterilized, at least without a compelling reason, right? And now that brought us directly to reproduction, not just parenting the children you have, but whether you're going to have children. And that also is in the 1940s. Then you really end up with Roe versus Wade with a key connection from those two things to Roe versus Wade, and that is Griswold versus Connecticut in 1965. And that challenged a Connecticut law that said it was illegal to sell contraceptives to even married couples. And the Supreme Court said in that case that there's a fundamental right of a married couple to make a choice about whether to bear or beget children, right? Now, if you want to talk about the weak foundation, right, what people mostly are talking about is actually what happened in Griswold, not what happened in Roe versus Wade, right? Griswold is where the court articulates this as a right to privacy. Griswold is where the court articulates it as coming from the penumbras and emanations of the Bill of Rights, right? Where it says, well, we have privacy in the Fourth Amendment against search and seizure, and privacy in the First Amendment about association, and privacy in the Third Amendment about not quartering soldiers, and so on. But so that's really where that foundation is. Now, do you think that's a weak foundation? It depends on what you think the Supreme Court is supposed to be doing when it interprets the Constitution, right? There are people in the anti-abortion camp who will say they're textualists. That's actually, first of all, made up, right? And kind of a meaningless thing, right? Most of the important constitutional rights are not mentioned in the Constitution, right? Including, as came up during the argument today, the very fact that the Supreme Court gets the final say on the meaning of the Constitution, that itself is not in the text of the Constitution. So what I think the Supreme Court was doing in not just Griswold and Roe, but in those earlier cases about parenting, was sort of saying, look, there are certain kinds of things that we can't imagine not having control over, and articulating a line where the government is not supposed to tread, right? And that's no less a strong foundation than any number of other things that we take for granted in the Constitution or that we think are unobjectionable, right? Was the Griswold opinion written in a terribly convincing way? No, but I accept the basic idea, right? That there's a sphere of family life that is supposed to be up to the individuals, where autonomy is the norm and in fact the highest value.
I actually happen to agree with you, and I think this is something that is lost in the discussion and debate around abortion rights, that it goes way beyond just the decision whether to terminate or to bear a child. Goes back to the 1920s, Meyer versus Nebraska, et cetera. So this is, I think, a critical question that bothers me. Given that abortion isn't just some separate sphere on its own island somewhere, that it's tied to other privacy, or whatever word you want to use, rights of the family, decisions about medical care, decisions about what profession you might want to have, decisions about where your child goes to school, how your child's educated. The question, do we want government intruding in this stuff? Should this be our decision, or should politicians decide? Do you think, Joanna, that if the court, and we can talk about this in a moment, but if the court does decide Roe versus Wade was wrong, that is that there is no right to against government interference when it comes to terminating a pregnancy, is that one stone's throw away from rolling back some of these other rights that we take for granted, or just part of being American? Or is there a principled distinction between, okay, well, we can say no right to an abortion, but don't touch my ability to choose whether my child goes to this school or that school, or gets this medical care or that medical care, or who I associate with, all these other sort of limits on our freedom. We talk about with masks, we talk about with vaccines. I mean, people really don't want government interfering. Is there a principled line between abortion and these other things?
No, and I think that came up in the Dobbs argument today. And so the Mississippi Solicitor General was asked, right, is there a line? And he said, well, yeah, of course, because abortion involves killing.
Right.
And obviously, killing is bad, right? So, first of all, the Constitution permits certain kinds of killing, right? The Constitution permits the death penalty. And the Supreme Court has opined many, many times that the government is allowed to kill as punishment, right? So that basic principle, of course, is not even true. But of course, for you to also think that abortion involves killing and is therefore different, you have to have taken a constitutional view of what life is, what constitutes killing, who people are, right? Where the Supreme Court so far, and what they said in Roe was, a fetus is not an independent constitutional person. So I think that's not a very satisfying answer. And of course, some of the anti-abortion folks who submitted briefs in the Dobbs case submitted a brief specifically saying the court should not only overrule all the abortion precedents, but should also overrule Obergefell versus Hodges, recognizing a right of same-sex marriage, Lawrence versus Texas, recognizing a right of consensual sexual behavior. And I think it's not that far of a step to get them back to Loving versus Virginia. I mean, why can the government not tell you who to marry? But it can
That was
tell
an
you
interracial marriage, anti-interracial marriage law that the court struck down. Yeah. So I think that I agree. This is a slippery slope. People don't. They seem to think we can just put abortion on its own, as I said, on its own little shelf. But let's back up. So we've got this right to basically keep government out of our decisions around whether to carry a child to term. That is where Roe versus Wade, based it on these various precedents. What did Casey do with that right? And what is undue burden balancing? Because if, correct me if you disagree, but that's really been the battleground until Dobbs. That is, how do you balance those things? Where it seems like now we're back to whether Roe is even good law, whether there's a constitutional right to begin with. Whereas before this, it's been a balancing act. Can you talk about what Casey did to Roe? Because now the court talks about them kind of together.
Sure. So Roe established a basic principle that a woman has a right to seek an abortion up to a certain point in pregnancy. And based on that idea of a right of liberty, a right of privacy within the right of liberty protected by the Due Process Clause. Now, in Roe, the court talked about the 3-trimester framework, right? And said at different points in a pregnancy, different interests are relevant and potentially compelling. So from the outset of pregnancy, obviously the woman has an interest in bodily autonomy, in decision-making autonomy, and all the things that would make us say, she ought to have some control over what happens, right? So that obviously attaches from the outset, actually before the outset, right? Because we have birth control cases and fertility cases. So she has that interest at the beginning. But what Roe said is that the government, although they might have an interest in protecting fetal life, that interest does not kick in at the outset of pregnancy, right? Because that first trimester embryo and eventually fetus can't live on its own. It's not an independent constitutional person, was a finding in the Roe v. Wade opinion. And so the state really has no interest in what happens to that embryo or fetus, right? And through the second trimester, that continues to be true, although the state's interest in regulating the safety of abortion becomes stronger in that second trimester, right? Those first trimester abortions, the court said, are incredibly safe, and there's really not much for the state to do to express any kind of interest in women's health. In the second trimester, they have a stronger interest in protecting women's health and in maybe regulating providers and regulating how it's done. And by the third trimester, the state's interest in protecting fetal life gets compelling, such that it is strong enough to outweigh the woman's interest in bodily autonomy and autonomous decision-making, unless it's her life or the fetus's, right? So her interest in staying alive always prevails, even through the third trimester, right? She's entitled to pick herself over a fetus all the way up to the end, if in fact it is a choice, right? It's her, only one of them can live. But otherwise, the court said in Roe that third trimester, the state's interest in protecting fetal life is compelling and therefore justifies an intrusion on her fundamental right to seek an abortion, right? So what happened in Casey, which was just about a little under 20 years later, Casey had a very similar posture to what we're seeing today, in that there had been a lot of anti-abortion advocacy, a lot of state laws passed knowing that they violated the current standard, and a hope by those advocates that the Supreme Court would revisit Roe and overturn it, right? Very much as they've asked the court to do in Dobbs. And what the court did in Casey instead was reaffirm the basic principle of Roe, that women who are pregnant have a constitutional right under the Due Process Clause to terminate the pregnancy up to a certain point. But it revised the framework for understanding that right and for thinking about how to balance the woman's rights with the state's interests. And so it jumped the 3-trimester framework, right? That still exists for pregnancy purposes. If you go to the doctor and you're pregnant, there'll be lots of talk about what trimester you're in. But legally, the trimester framework became irrelevant. And instead, what Casey said is the touchstone is viability. And so prior to viability, the woman's interest is strong and the state's interest is weak, but not non-existent. It said that the state's interest in protecting fetal life does not have to wait to kick in. It kicks in at the outset of pregnancy. And that from the outset, the state can do things to express its preference for childbirth over abortion. And it can do those things as long as it does not impose an undue burden on her right to seek an abortion. So if you step back and say, all right, what does that actually mean when you put all those things together? What it actually means is that pre-viability, abortion cannot be banned, but it can be regulated in ways that make it burdensome, as long as not unduly burdensome. And after viability, it can be banned unless the life of the mother is threatened, in which case still she's allowed to choose her own life over the fetuses.
So, what has happened, Joanna, across the country since Casey when it comes to actual laws? Because some people will argue, well, it doesn't really matter what happens to Roe because after Casey, this undue burden test has whittled away the right to abortion to the point where, particularly for low income women who can't travel to states where it's more available, they don't have access to it anyway.
Yeah, so Casey did unleash a sort of vast machine of anti-abortion laws, right? And all through this idea of undue burden. So what states did was basically accept the invitation of the Supreme Court in Casey to say, okay, you want to express your preference for childbirth over abortion, go, right? Now, what does that actually look like? States that wanted to do that, and that's a lot of them, started to pass a variety of laws, mostly in the vein of informed consent, to try to deter people from getting abortions or making it difficult. So what those laws look like, and every state is different, but if you look at a typical state, so and I'm just going to use Texas, that's where I live, for better or worse. I'm going to use, I'm very familiar with their particular laws. So Texas responded to Casey by enacting a variety of restrictions, and they look like this. If you want to get an abortion in Texas, and this is before SB8, which has been obviously been in the news this year and is a totally different game. I'm just talking about the sort of pre-existing abortion restrictions. If you want to get an abortion in Texas, you have to go in for a counseling appointment. At that counseling appointment, you must be given an ultrasound. For most people, based on the stage of pregnancy, that means a vaginal internal ultrasound, not an abdominal ultrasound. And that's true whether the doctor thinks you need one or not. You must have one. You must be shown the images on the screen and have them described to you whether you want them or not. The provider must try to detect cardiac activity and must do it audibly, whether the patient or the doctor want that. You must be given a pamphlet written by Texas called A Woman's Right to Know that has been criticized widely for having vast misinformation about the risks of abortion. And you must be given that pamphlet. And then there's a waiting period. So you have to wait 24 hours to actually get an abortion procedure. And you have to have the procedure from the same doctor who gave you the counseling. So you have to make sure that your schedule and their schedule match up so that it's the same person. If you're a minor, you have to do all of those things, but you also either need parental consent or a judicial bypass where you have to go to court and ask for permission. And that's a whole nother ball of wax. So that's the way that Texas has said, okay, fine, you have a right to abortion, but we don't want you to have it. This is what we're going to do. Right. That was one initial response to Casey. And you see those laws in a lot of states. Then
So
they
is it fair
added,
to say is it fair to say those are just shaming, guilt, fear, triggering, and just hassle? So even if it's constitutional, this is not an easy decision for the vast majority of women. It's not like people are using this as birth control as a regular, like using a condom, let's get an abortion. But the idea is we'll just make it so excruciatingly painful, both logistically and psychologically, that you won't do it.
yes, that is the idea, right? That this is supposed to be an unpleasant experience, and we want to talk you out of it. Now, add to that, then the sort of second wave after Casey of anti-abortion legislation was to focus on the providers, on regulating the providers. And part of the reason there was a shift is that first stuff actually did not really dampen abortion very much. For the most part, people who went to an abortion clinic wanting an abortion continued to want one until they got one. And that was the end of it, right? And so then anti-abortion advocates said, well, look, we got to get rid of the providers. If they have nowhere to go, then they won't be able to get abortions. And so that gave rise to the generation of so-called TRAP laws, the targeted regulation of abortion providers. And those were laws that said, for example, you can't, a person who provides abortions can't do it unless they have admitting privileges at a hospital within 30 miles. And abortion clinics have to be equipped like ambulatory surgical facilities, able to fit stretchers in hallways and so on. Well, this in fact caused many abortion clinics to go out of business because they couldn't do this, right? They can't get admitting privileges because abortion is too safe. Abortion doctors almost never have to admit a patient to the hospital. And even if a patient goes to the hospital, it's usually not right away. It's usually a complication a few days later, like an infection. So it's not that doctor, right? It's a more local doctor. So they can't get admitting privileges and they can't afford to retrofit their clinics to be ambulatory surgical facilities. And there's no reason for them to do that. So in Texas, they passed a law like that, but so did many other states. And that got challenged and went to the Supreme Court, right? And in that case, Whole Women's Health versus Hellerstedt, the Supreme Court invalidated those trap laws under Casey, right? And said that there
Undue
was
burden.
no, under the undue burden test, said there was definitely an undue burden, and that there was no justification because there was no benefit to women's health, right? And in fact, the Texas lawyer defending the law in the Supreme Court was asked, can you point to a single woman who was better off because of this law? And the answer was no, there aren't any, because it actually was all a pretext. So the Supreme Court struck down that law. However, in the interim, 40% of the abortion clinics in the state closed and didn't reopen, right? So it worked, even though it was unconstitutional, and even though the Supreme Court said it was unconstitutional, right? So if you look at any given state, Texas is actually fairly typical in that regard. There's this layer of restrictions on patients, there's restrictions on providers, and then funding, right? There's no public funding for abortion. There is a lot of states like Texas ban private insurance coverage of abortion or make it impossible for it to ever economically make sense. And you put all these things together, and what you end up with is a reality that abortion access depends more on your socioeconomic status than anything else, right? So people who live in cities have more access than people who live rurally. People who are white have more access than people who are not. People that live in high socioeconomic areas have more access, and so on. And so you end up with a world in which, on the one hand, it's fair to say that Casey basically ruined abortion. And on the other hand, there is this core right that's there. And, Texas, for example, has 55,000 abortions a year, right? There probably are more people than that who want abortions and can't get them for any number of the reasons I've mentioned. But there is still a pretty core level of access that if the Supreme Court overturns Roe, Casey, and all the other cases, Texas has a Roe trigger law that says abortion's a felony the second that opinion comes out. It's not going to be discussed, not going to be debated or voted on. It already is there. So that would be a pretty big difference in the Casey world of hassle, but 55,000 abortions, to Dobbs world in which maybe abortion is now a felony. That's a difference that matters.
Yeah, I wanted to, before we talk about the specific cases, just so people can understand the landscape here, I want to just throw at you some of the arguments that were raised in the briefs on behalf of people who want to see Roe versus Wade overturned. One of them is that, well, since Roe, women have had all kinds of advancement in their ability to be part of the workplace, their economic independence, advancements with the family, advancements with contraception, that this is not needed. We need an update to kind of get up to speed with modern society, because maybe women were in a lesser status in the 1972, in the 70s when Roe came through, but now we've seen so much of women's rights elevated that we just don't need something like a constitutional right to keep government out of early abortion decisions. How would you respond to that?
So a couple of things. First of all, part of the reason women have made strides is because of Roe, right? And there are good causal studies by economists showing that the availability of legal abortion directly resulted in improvements in women's economic security, career advancement, educational attainment, and so on. So not just a coincidence, but in fact, part of the reason some of that is true is because of Roe. So you take away Roe, you take away that access, you're going to take away some of those, right? We will see a rollback of some of those benefits. Another thing I would say in response is I think people have a very unrealistic view about how good life is right now for working women and mothers, right? Pregnancy discrimination is incredibly rampant and often unaddressed, despite the fact that it's often illegal, it's often unaddressed.
What's an example of that? What is pregnancy discrimination?
So pregnancy discrimination is can be any kind of thing, but that reflects bias or hostility to pregnant workers, or that simply treats them differently by, for example, exempting them from otherwise available benefits. And we see pregnancy discrimination, both intentional and sort of structural, that continues to be pervasive, right? So we have a really strong idea, no matter how modern we've gotten, we have a very strong idea about role conflict, right? That when we see a pregnant woman working, right, we have this reaction of like, oh, you shouldn't be working, right? You should be at home, sitting, watching, waiting, glowing, right? But not working. So we have, I mean, there's so much pregnancy discrimination litigation. It's kind of ridiculous, right?
So the idea being, if you do carry a baby to term, which Justice Barrett seemed to be hung up on safe haven laws, that is the idea that just have the baby and put it up for adoption. That, if anyone's had a baby, I've had four, that it's incredibly debilitating on your body. It's not so easy to just have a baby. But if we set that aside, what you're saying is just being pregnant has its downsides.
Oh, absolutely. I mean, being pregnant has downsides for work, for sure, but also physically, right? So pregnancy and childbirth are 14 times more likely to result in your death than an abortion, right? Literally, women will die because they are forced to give birth, who would have been alive. But there's nothing about pregnancy that's easy, right? There's nothing about childbirth that's easy. There's nothing about giving up a child for adoption that's easy, to say nothing of leaving one at a fire station and driving away. But it's also that this idea, part of the improvement, but also the unfinished work for women, right, is breaking down this idea about what women's purpose is, that they, were they put on this earth to simply bear children and raise them, or were they in fact meant to be full members of society? And part of what greater control over reproduction has done is helped start to chip away at those ideas. But we have a long way to go, right? Most women, for example, even if they work full-time and their co-parent works full-time, still do a disproportionate share of childcare, right? Sort of a 2/3 to 1/3 ratio, right? The United States is ranked basically last among developing countries for the safety net around parenting and work, right? So we don't have any mandatory paid leave. We don't have universal access to healthcare. We don't have any of the things that for example, the Global Gender Gap Report, any of the things that would make us a good place to be a mother, right? So the idea that, well, it's so much easier now to be a mother and to have a job that you should be forced to do it, right, is just a total misdescription of what the world is like, to say nothing of the fact that people maybe don't want that, right? That you're depriving them of this sort of self-determination and this ability to choose, what kind of life they want to have. The other thing I think was sort of striking in the questions today in Dobbs that related to this point is they say, well, we've made so many advances in contraception, and contraception is so cheap. And so all of the same people who are opposing abortion, including the Supreme Court justices, including the GOP legislators in various states, those people also all oppose access to contraception, right? They're the ones who litigated the cases or decided in favor of Hobby Lobby to try to reduce access to affordable contraception. They're the ones who have tried to cut Title X planning. They are the ones who have taken money away from Planned Parenthood to do women's health screening and contraception. They're the ones who have eliminated virtually every piece of a social safety net to support pregnant women, mothers, and families, right? So this idea that, well, you can just get contraception is just totally devoid of facts as well, right? They're the ones making it difficult.
To push back on that a little, I think their argument is, or at least counsel for Mississippi said, okay, but setting all that aside, abortions are really expensive, $500-600, and contraception is relatively cheap. So why don't women just use contraception to avoid unwanted pregnancies? There's your easy answer. Simple, obvious. I think Justices Sotomayor and Kagan would say, well, that's the same situation many years ago, but maybe they'd say, oh no, things have gotten better. Maybe it's still not universally available, but you do have that choice, essentially blaming the woman and saying, if you're having to get an abortion, that's your decision. That's your mistake that you didn't go to CVS and get a condom.
So a couple of things. First of all, contraception, even if used exactly as designed, which is an if, right, has about a 10% failure rate on average per year, right? And I forget if it was the Solicitor General or the clinic lawyer who brought this up today. But so you could assume that if 100 women were using contraception exactly as it was designed to be used, at the end of the year, 10 of them would be pregnant, right? Every year, right? So that's a pretty high failure rate that tells you control over contraception, even if you have it and you use it, right? You can afford it, you still have, there's a piece of that that's just not within your control, right? The second thing is contraception, in fact, is expensive, right? So if you think about reliable, long-acting, reversible contraception, such as an IUD, that also costs about $500 to $600 and will last for sometimes 3 years, 5 years, or 10 years, depending on what kind of IUD it is. But you have to have $500, $600, $700 up front to pay for that contraception. So it may be that a person can't afford that, gets pregnant, and then has to figure out how to pay for the abortion, but has a kind of desperation maybe that they can do. The other thing is that abortion funds in many states pick up the cost of a lot of abortions. So there are many more resources to pay for abortion than there are to pay for contraception, which is perverse, right? If the government provided access to free contraception, then maybe that wouldn't be the case. But I think, and people who take monthly pills or whatever, it's just not that cheap. It's not free. People think, they should use Plan B, right? The morning after pill. If you go to CVS, that costs $50, right? To use it once. Now you can get it cheaper at Costco or on Amazon. And I would encourage people of reproductive age to have some on hand so they don't ever end up at CVS or Walgreens paying $50. But that's not nothing, right? And in fact, in the litigation over Hobby Lobby and the contraceptive mandate under the Affordable Care Act, the Institute of Medicine, which is a nonpartisan think tank, did a study of what is essential for women's health, what preventive services are essential to women's health. It made a finding based on available data that access to contraception was an essential aspect of women's health, that the biggest barrier to contraception for actual women in the United States is cost, and that the only way to serve their health was to make contraception available at no cost to the user. That's what the Affordable Care Act required. And that's what all the same people in court fighting the abortion bans sued to get out of, right? Because they said, we don't want to pay for contraception. We don't want you to have contraception either, right? And Texas, at the same time they were trying to drive abortion clinics out of business, took an enormous percentage of their family planning budget and redirected it to crisis pregnancy centers. and just took it out of family planning completely. So at the same time they restricted abortion, they restricted contraception. So in some sense, you can't have it both ways, right? If you want to go to court and say, I'm pro life and I care so much about this fetus and I don't want this to happen, right? Then you cannot support the rest of these kinds of policies, but that's not how it is. The last thing I would say in response to that is, and I think today in Dobbs, it was sort of unfortunate. There was so much focus on the unplanned pregnancy as being the reason for abortion, as opposed to something that happened with a planned pregnancy. So for example, women sometimes are diagnosed with cancer while pregnant, right? And they have to make a hard decision, perhaps. Do I want to continue this pregnancy and defer treatment, or do I want to have an abortion and begin treatment immediately? That's not addressed by contraception. Women who are pregnant and discover severe fetal abnormalities, ones that are incompatible with fetal life, those, for the most part, cannot be diagnosed prior to the 16th week of pregnancy, right? Most of the prenatal testing and the time when certain kinds of defects become visible on an ultrasound or through chromosomal testing or whatever, most of those things make themselves known between about 16 and 20 weeks of pregnancy. That is when you find out, perhaps, that the fetus you wanted and planned for is not going to survive, right? Those people need abortions too, right? And those people need abortions after 15 weeks. So none of this is sort of a response in my mind to abortion, right? That is, there are always going to be reasons why people choose abortion. And we know from the research that when people want abortion and are turned away, that they suffer pretty tangible consequences, right? They suffer economic harms, they suffer emotional harms, they often suffer physical harms. So there sort of is no substitute for abortion. If you want to minimize abortion, the world would look very different than it does, right? There are things you would do to minimize abortion, but they wouldn't be the things that we're currently doing.
So I want to get back to that question, as then what's actually going on, but a few more things that came up in oral argument and in the briefs. One is I think it was Justice Alito. So, okay, we have all these interests for women, and Justice Kavanaugh sort of said this as well. We're not denying women have interests. I think Justice Barrett said it too. But what about the interest of the fetus? The fetus has an interest as well. So that's I think one argument. And the other argument is, and by the way, this is just Chief Justice Roberts. By the way, viability has no. Comes out of nowhere. Undue burden comes out of nowhere. It's not. It's not even tailored, to use Chief Justice Roberts' words, to this idea of choice. It seems arbitrary. So then the third piece would be, so why should we even be involved in that? Send it all back to the states, let the states and the voters decide, because there is an interest in fetal life. And to use Justice Kavanaugh's argument, we're balancing interests. That's not really something we should be doing. And Roe is unworkable, and there is no real test that we can replace it with.
So there are a lot of things packed into that
Yeah.
question. So if I miss anything, you get me to come back to it. But first of all, the idea that we should get rid of Roe because it's unworkable is sort of ridiculous, right? It's unworkable because the people who don't like it have tried to make it unworkable so that they can then come back into court and say it's unworkable, right? It's actually not unworkable, right?
So it's actually scientifically, when you talk about viability, it might move based on science, but the idea is, okay, can the fetus survive outside or not? It's not a religious test. It's not a subjective test. It's not a balancing test. It's pretty much, what does science say? If the mother is completely in charge, that is, the fetus can't survive, then it's the mother's exclusive choice. Otherwise, we're going to bring in the government's interest and allow that to be regulated.
Yeah, but viability also has a scientific basis, but it also has a logical basis, right? The idea is, at what point does this fetus cease to be solely a part of the woman and begin to be something independent, right? If you take out a 16-week fetus right? It isn't anything, right? It isn't alive. It isn't a baby. It isn't a person because it can't survive, right? It is a part of her body, right? And it exists only to the extent that she is nurturing it internally, right? So the idea of viability is, well, what if that wasn't true, right? What if there was a premature delivery and the fetus could live? Doesn't that start to seem more like we're choosing her over the fetus, but they're both maybe people, right? That's the logic of the viability, right? So when you get rid of viability, then what are you left with, right? What is the difference between a ban at 15 weeks and a ban at 10 weeks, or a ban at 10 weeks and a ban at 6 weeks? It doesn't mean anything. The point is, until the fetus can live on its own, it isn't an entity, right? It isn't a constitutional person. It isn't a person at all, right? And
Well, this
our
is
entire
why.
law is structured based on this idea that people get rights when they are born, right? That's when you count.
But also, I mean, I was on MSNBC earlier, and Pete Williams came out and said, "Oh, it's really, it's clear they're going to uphold the Texas law, but they're not necessarily going to disturb Roe versus Wade." I don't see on the table, Joanna, some alternative test. To me, it's there. We're not talking because I think there isn't another test out there other than viability that's even been proposed, let alone one that makes more scientific or logical sense. So I don't know what that alternative would be. I know the justices think this is arbitrary, but without getting rid of it completely and just saying there's no constitutional right to abortion, maybe I'm missing something. I'm not seeing another alternative. Are you?
No, I don't think there is an alternative, and that's of course exactly what they want, right? I mean, the middle ground position, if in fact they don't overturn all the cases, will be we junk viability, and it's now just an undue burden test all the way along from beginning to end of pregnancy. States can do whatever they want as long as it's not an undue burden. Then there's no right left, right?
Which is
There's
rational basis, which is what
right.
Mississippi came out and said. And for viewers who don't know this, it's the lowest standard essentially. If the state can articulate a reason to pass a law that affects people, then it's good. They just have to have a reason that seems rational. And so it's the equivalent of getting rid of Roe versus Wade.
Right. And states will have no problem doing that. I mean, there just is no substitute for viability, as I said, because viability not only scientifically is more objective, but it logically makes more sense, right? We don't generally have in our society an idea that you have to give up your own freedom or autonomy to help other people, right? Look at the debates going on around something as simple as wearing a mask, and you see how strong that is. Or look at the law on stand your ground and the castle doctrine that allows you in many states to kill an intruder into your house, even if they are threatening only your property and not your person, not your body, right? Or your life. We have this idea of, no, this is mine, right? I get to do whatever I want, right? So, we would never say to someone, hey, listen, you have to donate bone marrow, right? You're a match, and there's a kid down the street who has cancer and is going to die if you don't donate bone marrow. Too bad, right? You can't you couldn't force me to do that, right? But you could force somebody to carry a fetus that cannot live outside of your body, right? And might be actively harming you, right? Fetuses are harming you in at least mild ways all the time, right? But might be more actively harming you. And yet you have to choose the fetus's life and health over your own, right? But you don't have to do anything else for anybody.
So what's going
Why?
on here? If you're saying this isn't really about stopping abortion and that, okay, they made the arguments today, well, they should just get contraception, but they're also, the same group doesn't want contraception. I mean, what is going on with politics being sort of all about women's bodies and women? Do you have a theory on that? What is the end game here?
Misogyny, right? I mean, misogyny is the motivation. The end game is women go back to their place, right? This entire modern anti-abortion movement is driven by people who are very threatened by the idea of women being equal participants in society, right? The very things that they cite as being advancements that mean abortion isn't necessary, like, oh, look how well women have done in the labor force and with, pay and so on. They actually don't like those things. They don't want it to be easy for women. They are more comfortable in a world in which who's who, the sort of Archie Bunker, right? Girls are girls and men are men, and who's who. And you see the same thing running through the anti-trans movements, which I think originate from the very same basic idea, which is people have a place and gender is the primary determinant of what that place is. And it's actually, and I think they think it's really unnatural for a pregnant woman to want to not be pregnant, right? That actually is something they can't quite accept, right? Which is why you see in some of those abortion cases, talk about what women would regret, that they obviously would regret abortion in certain circumstances. The data says that isn't true, right? The data says that the overwhelming majority of people who have abortions feel relief as the primary emotion. They actually are not terribly conflicted about it. That most of them do not view it as a very difficult moral decision. They view it in more pragmatic terms, which is, I don't want to be or can't safely be pregnant right now. And this is the way to solve that problem. But we have this idea that, well, but you're already a mother, right? You're pregnant, this thing is growing inside you. And the womanly thing to do is to wrap yourself around that helpless being, right? And do whatever it takes, even if in the end you abandon it at a fire station, right? That's the womanly thing to do. I mean, I think that's what drives all of this. I mean, it gets couched in religion, but first of all, the religious basis is weak at best, if not outright pretextual. I am not a theologian and I don't opine on such things, but the Bible talks about life beginning at breath. Judaism says abortion is actually a necessary component of humanity, that a woman has to have access to abortion because her life matters more than the fetus. There's a comparable principle in Islam about the power of women to make that decision. So it gets couched now as being a fight against traditional Christianity and a fight against traditional religion, but that was never what abortion was about or anti-abortion was about. That's just wrapped up in this modern political drama, right? What's really going on is that it's a fight for power and a fight over women's place in society. And I think what we saw today in Dobbs is women are losing, right? They're just losing.
So Dobbs is a 15-week ban in Mississippi. So that's earlier than the viability test that we talked about. Then we saw Texas, a 6-week ban at 6 weeks. That is, which had this, we don't have time to talk about, but had this weird procedural sort of outsourcing bounty hunter mechanism that was really about avoiding any judicial review. But I think it's striking that the Supreme Court allowed for 3 months now that unconstitutional law to sit there. When I say it's unconstitutional, whether you like Roe or not, that's the law of the land, and this Supreme Court is allowing the Constitution to be violated every day as we sit here. What do you, I know it's hard to predict, but it sounds like you're not optimistic. What do you think is going to happen with this court with Dobbs, Dobbs is the case again that's striking right at the heart of Roe. We're not balancing burdens. We're saying we're getting rid of this protection against government interference in pregnancy.
My best guess is, based on the argument today, is that they have 5 votes to overturn Roe and Casey completely, which I would not necessarily have predicted in advance of the argument. But I think they have 5 votes to get rid of all the abortion cases completely and just say abortion is just simply not protected by the Constitution. And so we're getting out of this business completely. I think they have 6 votes to uphold the Mississippi law. I think the 6th vote would be Roberts, and it would not get rid of the whole line of cases because he at least purports to care about the legitimacy of the court, but would say there's no magic in viability. And so 15 weeks seems like it gives people a reasonable opportunity to obtain abortion. And so it's not an undue burden to have that be the cutoff. And then I think in the Texas case, I think the court strikes it down, although why they haven't done that yet, I'm not sure. There clearly were enough votes, probably 7 votes, to block the Texas law, but it will have nothing to do with abortion. They won't reject a 6-week rule at all. They'll leave that open after Dobbs. But they will say that the state is trying too hard to get around the federal constitution and trying to deprive access to the federal courts, and that's why the law is invalid. And they'll do that because they don't want that done to gun rights. Won't have anything to do with abortion. They do not want that kind of law to be able to curtail the rights they care about. So at the end of the day, I think next June, or maybe sooner, but probably next June, we will say there is no federal constitutional right of abortion. The Texas 6-week ban gets struck, but then is replaced with the Roe trigger law that now makes abortion a felony. So I think the real question is just simply what comes next, right? I think that is going to be what's going to happen. The what comes next is going to be interesting, and I don't mean that entirely in a good way or a bad way, right? Because one thing that's going to have to finally be dealt with is the fact that abortion rights are very popular, right? Abortion enjoys support of as many as 75% of the voting population, including in states that have banned it, right? So in Texas, 51% of voters say no abortion bans, right? And 60 to 70% say SB 8 is wrong. How did it get passed, right? How is that possible? So you have this situation in which, due to voter suppression, political gerrymandering, and a few other things, right, you end up with abortion laws that are far out of step with public opinion, more out of step than Roe was, right? Roe actually had majority support. These laws do not. So then what happens, right? We can send this back to the states. The immediate effect is red, blue, looks like the presidential election map, but now it's abortion, right? The immediate effect is whether you have rights depends on where you live. Abortion funds become a central aspect of the economy because people are going to have to be flying all over the country to seek healthcare. But the sort of 2 to 5 year picture, I think, is much less clear, right? Like, what happens when people are forced to realize this is what they voted for, right? This is how we're going to live now. They aren't going to like it, right? They aren't going to like it because they didn't like it even in 1972, right? We didn't like living in that way.
How likely will this turn? You mentioned Texas. How likely will this get into the criminal law realm where women are prosecuted for getting abortions, do you think?
So for the most part, the history of criminal abortion bans has been targeting providers, not patients. And that's true in the Texas law. There are a couple of Roe trigger laws in other states that do criminalize the patient's behavior, not just the doctors. Although, like I said, historically, the criminalization has been focused on providers, figuring they're the ones that can be deterred, and that it seems sort of unseemly somehow to criminalize the actual patient's behavior. But I think in this current moment, all bets are off, right? I don't think people are not bound by history. They're not bound by respect for women's lives, clearly. So will we start to see more laws that target the women themselves? Yes. I mean, there was a law introduced, a bill proposed in Texas, which didn't pass, which would have made the patients their behavior criminalized and asked for the death penalty as a possible thing. There's an Alabama law that's proposed, and I can't remember if it passed, that said that. So I don't think it's out of the realm of possibility. It wouldn't be the norm. But once you move the goalposts of Roe, I don't think we know exactly what we're going to see. And I'm not sure what the Republican Party looks like after Roe is overturned, because mostly they like Roe existing and hating it because they get to use it to mobilize voters, and they don't have to deal with the fallout of the fact that it's actually not what people actually don't want Roe overturned. So it's this weird policy plank that
Yeah, I think some Republican strategists would agree that this could open a floodgate of real problems for the party. I mean, we're on this trajectory of single party state and the dissolution of democracy and majority or minority rule, all these things. And that trajectory could turn around. I think some Republicans are worried about that. Last question, and this is really for the viewers. People are going to watch this and be really scared, particularly women. And what can people do, Joanna, to push back on this and, not just completely just lose faith in their futures, frankly, which like my own children and I've talked to students about. They say, listen, this is not something you faced. This is a different world for us. What would you say to those people that are really worried about what happens after June, if your predictions about this court are correct?
Yeah. So, I mean, even if my predictions are not right, right, even if it's not quite as bad as I predict, it's still bad. Right. So I would say that anyway. Yeah. I mean, I have a lot of students who sort of look to me and say, but, well, but it's going to be okay. Right. And I actually don't think it is. I think we're actually at that kind of watershed moment where we are really taking a giant step backwards. So what do you do about that? One is politics, 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 right? Because the reason this has happened is because of the GOP takeover of state legislatures, even when they are a minority party, right? Even though they, like in a state like Texas, they do not have more voters. Their policies are not popular, right? The Republicans in Texas don't have a single policy plank that enjoys majority support. And yet there's not a single statewide office holder that's a Democrat, right? The entire Supreme Court and the entire executive branch is all Republicans because of what they've done to voting and et cetera. So you have to get involved in politics. And if you get involved in politics, you realize there's this incredible infrastructure there, but you got to be a part of it, right? It is people driven, right? And it is like sweat driven. And I think in the abortion context is to realize there's this incredible network of people working for reproductive justice. Every issue, every layer, every place, and figure out who's doing what and how you could be a part of it. And then I think on the sort of very individual basis, what I always tell, younger women and, teenage girls is, you have to take responsibility for educating yourself, right? About your body, about your options, about your rights, about what you would do if certain things happened, right? I sort of kid about telling people, make sure you buy Plan B on Amazon so you have it on hand. I actually think that's very practical advice because you just aren't, for at least some period of time in the future, you're not going to have the same options that I had as a 20 something or a 30 something, or as you had. They really are going to live in a world in which their options have been curtailed. So you have to sort of live in that world for a while, right? While you're trying to change it, you also have to live in it, and you have to take control over reproduction, over sexual health, reproductive health in ways that take on new meaning, right? And new importance. And I would hope there would be some push, there probably won't be, in response to this, to improve sex education, which is a disaster in this country, especially in Texas, to improve access to contraception, right? To support working women, pregnant, working mothers, right? Paid leave got dropped out of the the big Build Back Better bill because it was just too controversial, right? The idea that people should be able to take 4 weeks off after having a baby, too controversial, right? Those are the things you have to work on. But I don't think the abortion wars are ever over. So I don't think it's the case that, oh, well, they won, right? Just like it wasn't over in Roe, right? 50 years later, this is the fallout of the anti-abortion advocates never giving up, right? They won. Maybe they're going to win. Well, what's going to happen 50 years from now or 10 years from now, right? I think the social demand for abortion is going to drive the next 5 years, the next 10 years. And younger people need to be a part of it, and they need to vote, right? Younger people change things, right?
Yeah, absolutely. And maybe we can see more, civil rights movement around the rights of women and gender, which I think we just assume is second class in many ways in this country. We just take that for granted. So, well, Joanna Grossman, thank you so much. I've learned a tremendous amount, and I know our viewers will as well. I appreciate your coming on Simple
Oh,
Politics.
it was a lot of fun. Thank you.
Thank you. So thank you everyone for watching. I'm Kim Whaley.